We've got new details today in the controversy surrounding former Yale University basketball captain Jack Montague. In a statement released Monday, his lawyer confirmed the former student was expelled last month for sexual misconduct allegations and said he intends on suing the school.
Jack's lawyer went on to say that he has been pilloried as a whipping boy for a campus problem that galvanized national attention. CBS News legal analyst Rikki Klieman is here with us now to walk us through this very interesting case. What did the lawyer mean that he was being used as a whipping boy?
What the lawyer was saying is this: isn't the timing coincidental, says Max Stern, the attorney for Mr. Montague. He says there was this study on sexual assault on campus, and what we found out was that the big headline was that 1 in 4 women were saying at college campuses that there was sexual contact they didn't want, and Yale, of all the schools, Yale winds up with a 34% of women who are seniors who have been sexually assaulted. So the defense lawyer here, Max Stern, is saying, hey, isn't this coincidental? In an overabundance of caution about wanting to protect women, Yale here is making this young man an example, according to the defense.
And so what specific allegations could Montague use against the school? What could he say that they're taking away from him?
What he is trying to say really falls into 2 columns. One, I think, which is potentially more successful than another. He says, look, I didn't get any due process here. What does due process, which is a constitutional violation, really mean? What we have is a group of people in a secret hearing who are part of the university and part of the group that is looking at issues of sexual assault. So I didn't have a fair judge or jury. Then he's going to say the burden of proof here to say that I violated school conduct rules, that it's a violation of school policy, is what we call a preponderance of the evidence. Let me just show you what that is. You have scales of justice. A preponderance of the evidence is 1 little feather. That's all it takes. So if her story is worthy of belief, he can then be expelled. And finally, on due process, you have no right to confront your accuser. That is, the boy and the girl, or the man and the woman, are brought into this group of 5 hearings officers, and they must be brought in separately. They can't see each other. They can't ask each other questions. So he says, my due process is violated. I have irreparable harm. The thing I think won't be successful is the issue of slander or libel, because Yale didn't say that he was a rapist.
It was this girl or this woman.
And it was the students. So the students may have put up posters and the students may have written in chalk, but ultimately it's not Yale that's responsible for that.
So moving forward, though, because I mean, what you're describing to me, I think some could argue is somewhat of a flawed system when dealing with sexual assault. You know, she didn't go to the police, so you don't sort of have the legal restrictions or the legal burdens. It's a group of people determining which he said, she said, and who's right. What sort of legal precedent do you think we could see hammered out here moving forward?
I think that this is a big case because it's garnered so much publicity. There have been a few lawsuits by young men who were booted out of school or otherwise reprimanded in some way or other and therefore labeled as racist. What you have to do is find a balance here, and we haven't been able to find it yet. The Title IX, which we're dealing with federal legislation of the Civil Rights Act, what we're doing now is we needed, as a society, to come to the aids of victims of sexual assault on campus. It was clearly rampant. But in that move to protect these women, and it's usually women, we've gone overboard and forgotten about the rights of the accused. So the universities are struggling, and I do think that this case, if it actually goes forward and doesn't settle somewhere along the line, that this could have precedential value, not only in the law, but also in how universities are going to have to look at these cases in the future.
Rikki Klieman, thanks a lot. It's very interesting.